Okay, good morning.
Good morning.
Morning, Your Honor.
Okay, I'm Judge Evander. I'll be presiding over the case today, and we're here on Spring Isle versus Hermey 20-1420. Let me introduce the other members of the panel. We have Judge Ardella and Judge Wozniak. Each have 20 minutes aside for argument. These arguments are being both live streamed and recorded, so the members of the public can view it. As far as warning, how much time does appellant's counsel wish to reserve for rebuttal?
5 minutes, Your Honor.
Okay, I'll try to help in that regard, but you should have a clock on the screen there. Okay, with that, appellant's counsel may proceed.
Thank you. Thank you very much. May it please the court, this is Scott Kiernan for the Appellant Spring Isle Community Association. This case is about what is the correct trigger date for the statute of repose under Chapter 9511(3)(c). And the legislature actually tells us under the 2016 version, which is the one that we're operating under today, the trigger for the 10-year statute of repose cutoff is actually a number of things. It can be possession by the owner, issuance of CO, certificate of occupancy, abandonment of the construction project, or date of completion or termination of the contract between the engineer, the registered architect, or the licensed contractor. And it's whichever date is latest. There can only be one date for each construction project. And the trigger date is always the latest date. Here, the lower court, the trial court, says that CO is the date. It can't be the date. There's still performance that has to be done under the contract. The trial court even admits final performance and final payment is when completion of the contract happens. Yet, surprisingly, rules each townhome unit completion was final payment. That's just not possible if you still have to perform under the actual contract. There's 61 more units that need to be stuccoed in this community. There can only be one breach of contract. It's the master.
Talking about the breach of contract, can you walk me through what the contract is here? And what I mean by that is the elements of the contract. What was the offer? What was the acceptance? And what was the consideration? And when was it over?
Right, I understand. Yeah, so we have what's called a master subcontract agreement. It creates the relationship, the boilerplate terms, the stucco, what they're supposed to do. They're supposed to stucco the community. This is the contract. This is the actual contract. Now, it states that all work will be in accordance with a Schedule A that's issued on each job that they need them to work on. In this job, it was the Spring Isle community. So there's two Schedule A's because this community is so large. It's got 390 townhomes, plus all of the single family homes they need them to work on. So acceptance is when they sign the actual contract, the one main contract, the large agreement that, yes, we will stucco all of your communities within the Amaster Orlando division.
So
and
that's
for each community,
the subcontractor contract, or also called the master agreement, I think. That
yes,
alone is the contract.
That's the contract.
That's your position.
And,
Okay.
Mr. Kiernan, following up on that, you signed the subcontractor agreement, not you, the Pulte and Hermey signed the subcontractor agreement on May 19th, 2004. If the very next day, on May 20th, 2004, that day, Hermey had approached Pulte and said, we want $1 more or we won't perform. We want $1 more for our work, or we're not going to show up on a single job. Could Pulte have sued Hermey for breach of contract on May 20th, 2004?
I believe, yeah.
Okay. What does
Yeah,
that
I believe they
look
could.
like? What do you cite for the contract language that would support that there was a binding contract at that time before a job order was issued that would allow Pulte to sue for breach?
Sure. I mean, you have an actual contract. You have both parties signing the contract. You have both parties agreeing to perform under the contract. The only thing that contract says is there's going to be a Schedule A for each community that's going to be issued. And it's going to outline exactly what you need to do in that community. The work orders, those minor work orders, they don't create a new contract. We don't have 390 mini contracts. We have one large contract. Both parties signed it. It's a plain, clear, ambiguous language of the contract. It's an agreement that you're going to perform all of the stucco work in the Orlando division for us.
Now, it's clear from the contract that Pulte could have walked away, correct? So Pulte could have issued job order number 1, and Pulte could have walked away on job order number 2 and given the entire work on the Schedule A's after job order number 1 to some other contractor. But it's
Right,
your
they just have to
position that
pay.
Herme and Subcore could not have walked away.
That's right. They just have to pay for what work has been performed. If they said, hey, we need you to do, we're going to issue a work order on one of these units, and they do the work, they still have to pay for that work. But after that, they have the right, under the clear language of the contract, we can terminate the contract at that time. And again, all the essential terms are in Schedule A. So it's almost like a unit price contract, which is very standard in the construction industry. So it basically just says, here's the range that you're going to have to work under from 2005 to 2009. We're going to construct these units. And they were all constructed within that range, by the way. 390 units were constructed by 2008. And so the Schedule A's, they are incorporated into the master contract, and that's for the entire community. The work orders are not the contract. They are an exhibit that's incorporated into the contract, but the Schedule A is actually the unit price contract. The contractor issues the job work orders on a house-to-house or building-to-building basis, and commencement in the work order constitutes acceptance of the terms in the only contract, the contract agreement.
So the work orders are not in the record, correct?
Right. There is no work order in the record, and that's what they relied
So we
on.
don't, I mean, theoretically, the work order could say this will be considered a separate contract between Pulte and Herme, or it could say this is a work order pursuant to the larger contract executed by the parties on such and such a day, including the Schedule A's.
Yeah.
So we don't know what the work order says.
Right. Exactly. That's a big point, because they're relying on the work orders at the summary judgment level. They don't have the work orders. And they say, well, Pulte doesn't have them either. Well, I'm not moving for summary judgment. They move for summary judgment. So the work orders, what they do is merely a notice to commence the work on a particular unit within that date range of the Schedule A. That's all it says is, okay, here's the work order, go out and do. If you were in breach of the work
If the
order,
work orders are never found, can the parties, if they go to trial, resort to things like course of conduct between the parties and whatever testimony either side can gather from witnesses to fill in gaps?
yeah, there is no work orders produced by them in this case. In moving,
Well, there's no work orders produced by Pulte either.
That's true. That's true. And but here's the thing, if they said, well, we're going to sue for breach of the work order, you can't sue for breach of the work order. That's not, you would be suing under the contract. We have a breach of the contract. Somehow the parties have a breach. Okay, you'd be suing under the contract. You're not suing under the work order.
Unless
work
the
order
work
just
order
tells
said
them
it
when-
was a separate contract.
What's that?
Unless the work order said that it was a separate contract.
That's
and had
correct.
terms. Okay.
That would be, yeah, freedom of contract. Yeah, you are absolutely right. Downs versus US is a case right on point here. Completion of a sub-agreement is not the trigger for repos. Repos is calculated based on the completion of the entire project, not just a mini part of it. You can't say, oh, well, this is just a mini subcontract. Well, that's not what Downs versus US said. The court must look to the entire construction project. And even more importantly, right out of the Fifth Circuit, a case that really isn't addressed much by the appellees is Allen and Conrad versus University of Central Florida. The court looks to repos as the date when the improvement to the real property has been completed, not to the date when a particular party's participation in a project has been completed. And in that case, Allen and Conrad were the architect. And they said, well, where our work is done, so statute of repos applies to us. And this court said, no, that's not true. You have to look to the entire project. The contractor still has not performed their work. So the entire project is based on when the last person on the project completes their work. That's when the statute of repos is triggered. And that case is directly on point here. Lindemann, who is the engineer in this project, there's records that they actually performed work approving the project well into 2008, well within the 10 years. Who else was performing work on the project? The appellee. Herme and Simicor were still performing work on the project well into 2008. And Allen and Conrad is right on point with that. So even if Pulte and the appellees, upon completion of each work order, the subcontracted agreement between the parties was not completed, because here's another thing. They're just mere progress payments. Okay, you finish this unit, you're getting paid on this unit. You finish this house, you're getting paid on this house. These are just progress payments under the contract. And the stucco for 390 townhomes, not to mention every other single family home in this community.
Is there anything in the records, any summary judgment evidence, which state that those payments are progress payments, or alternatively, whether they're payments for a particular work order, or do we know?
Well, they
We
actually,
just have the dates of payment.
right. They have to be progress payments because completion of the contract wasn't done yet.
I know, but I'm asking you whether there's documentation which identifies or describes those payments in any particular terms.
Not that I can think of right at this time, Your Honor.
I mean, none that
But-
say this is a progress payment, none that say this is a final payment.
No, and that's the thing.
We just don't have the documents.
Right. But there are house cost control sheets, there's payment records, and you have Pulte's corporate representative saying, yeah, we pay them after each job is done. But when asked in their deposition, well, but they only have one contract for the whole job. That's correct. We pay them for the job, and then a CO is issued on that particular home or in that particular building. Actually, it's issued on each individual unit, but then they still have to, Pulte says, you still have to, we're going to build 61 more. You still have to come out and finish 61 more. Under what? Under the contract. When the contract is completed, that's when that's when statute of repose is triggered. And
Let me
that's
ask you this, as far as summary judgment evidence, you have buildings with 4 or more units, I understand.
yes,
So
4 to 6.
can you finish one unit only, or do you have to do a building at a time, or was there any summary judgment evidence on that?
You can finish, I mean, they could say, hey, we just want one unit finished in this particular building. And then for whatever reason, maybe they stop in the community, maybe they go belly up, but the contract was for them to perform everything in the entire community. I mean, the problem I think you're going at is these buildings have 4 to 6 units apiece. So the trial court's ruling arguably says, well, some of the units may have a right to sue, but the other ones don't. I mean, this is the half roof dilemma. How can you say that in a building that 2 of the units may be within the repose period, but the other 2 units in the exact same building don't have a right to bring a claim? I mean, the community's just, that would wreak havoc and defeat the association's claims, any association's claims throughout the state. And that's not the legislative intent of the statute. So you have a community that's not finished until the last building is done, and the contract is binding and enforceable, even on, they can say after 389 units, well, it's still not done. You have 1 more unit. We want you to finish the next unit. And so it's just not possible to say that, okay, well, we're just going to complete half of it within this building, and only half of these people will be within the termination period. And also a point I want to make is that for each occurrence, the appellees must prove evidence of occurrence for the 4 triggering events in the statute of repose. They don't even have the work orders. They can't produce those at the summary judgment level. It's their job to disprove all of the 4 triggering events. The corporate rep for Pulte, they gave no testimony on what the actual completion date was. They just, well, it's based on what the payment records say, what the payment records may or may not show. And it was not Pulte's burden to prove the evidence. I mean, this is Hal v. Talcott. Again, another case right out of the 5th district here. Party must overcome all reasonable inferences which may be drawn in favor of the opposing party. And summary judgment is only allowed if the proven of non-existence of a genuine issue of material fact.
Mr. Kierman, there was Hermie and there was Semacore. Did Pulte enter into a separate contract with Semacore when Hermie was done, or did Semacore take over Hermie's contract with Pulte?
Yeah, that's a great question. It's just merely a name change in the middle of the project. They did ultimately enter into a new contract with Semacore, well within the 10 years, I might add. And so they just entered into they continued to pay him as Hermie for the longest time. And then they did realize that they have to enter into a new agreement. So what did they enter into? A brand new master contract, the only contract that they have in this community. They realized we need a whole new contract.
When was that?
That was late in 2008. Yeah, that was late in 2008. Sorry, I have that on me. I believe that was sometime around November or September of 2008.
But within the repose period.
Right, within the repose period. Even if it was November of 2007, it would still be within the 10-year statute of repose.
Okay, so why did Pulte then enter into the new contract with Semicor at that time?
I'm sorry, Your Honor. Yeah, good question. Because of the name change, Hermie had notified Pulte, hey, we're no longer operating under Hermie Industries or Hermie LLC. This stucco company is now going to be called Semicor. At that time, Pulte realized, okay, well, we need a whole new contract between us, the only contract between us. And that's at that time when they entered into the new contract at that time with them. Can I reserve my 5 minutes, please?
You may. Okay.
Thank you.
For the appellee.
Good morning, Your Honors. Randall Rowe for Appellees, Hermie Enterprises, and Semicor Enterprises. This case is about whether the 10-year statute of repose found in Florida Statutes 95, 11(3)(c) can be applied to individually completed units in a multi-unit subdivision based on each individual certificate of occupancy for each unit. The trial court correctly found that it could. The certificate of occupancy date was the correct measuring date of each unit, and as you've heard, the appellant's main arguments focus on different alleged trigger dates based on an analysis of the completion of the contract prong of the statute.
Mr. Rowe, go ahead, Judge.
No, go ahead.
I want to ask you the same question I asked Mr. Kierman. Can you walk me through the elements of the contract here? What was the offer? What was the acceptance? What was the consideration? And when could a party have sued, going on Judge Nardella's question to Mr. Kierman, when could a party have sued under this contract?
Well, so the work orders are the operative contracts you look at, and the offer to Hermie was, we offer you to apply stucco to X amount of units listed in these work orders. Hermie's application of the stucco is the acceptance. Either side's breach of that work order is what you could sue on.
So the master agreement or the subcontractor agreement and the Schedule A's, are you saying that's the offer? And then the stucco company's performance is the acceptance? Is that what I'm understanding?
No, so the master agreement contains boilerplate terms regarding insurance and indemnity that apply to any project that Pulte could ever retain Hermie on in their existence with no clear termination date. So there's an offer saying, hey, in future projects, you'll agree to these boilerplate terms. Hermie signing that agreement constitutes the acceptance, and there could be a breach of those insurance requirements, whatever, later on. But because that doesn't obligate Hermie to actually perform work at the project, the performance of the work itself may not constitute a breach of the master agreement. Schedule A's, you have a similar issue. The Schedule A's still don't retain Hermie to do work on any project. They only set pricing terms. And so if Hermie says later on, well, we're not going to adhere to those pricing terms, we're not going to agree to that, Pulte doesn't have to sue them. They just don't issue any work orders for work. They just go to a different subcontractor. And so that's how these contracts are set up. The operative contract to look at is the work orders. We have a yes, Your Honor.
No, I'm sorry, finish.
I was just going to go off into my argument.
So to me, this case turns on when the contract becomes binding. And my question to you is, what evidence do you have that the contract does not become binding? There's not a binding relationship between Pulte and Semicor or Hermie until the work order is issued. What language would you point me to?
Well, so there's multiple language and multiple agreements here. So the master agreement, which has a lot of language, such as the duration of subcontractors work under this subcontract is unspecified, things like that. But it also states that Pulte shall issue written job orders on a house-to-house and or building-to-building basis, which is indicative of the fact that Pulte is contemplating that these work orders will exist. The Schedule A's, when you look at the Schedule A that was issued to Semicor in November of 2005, it also states that prices in that Schedule A are, quote, effective only for new purchase orders released after the effective date. So this document continues to contemplate that new work orders, purchase orders, whatever you want to call them, that they're going to exist. And so you look at when these work orders were issued, Hermie's performance of work indicates that they received these work orders and complied with them based on what this language says, and based on the testimony of Pulte's corporate representative, Mr. Pierce, because he testified that this is how Pulte operates. They're going to issue these purchase orders. That's going to retain the subcontractor to come work, and then the payment to the contractor will indicate when the contractor's work on that unit was complete. And so you have this argument that's being made here about the missing work orders, and I think that's a big elephant in the room that the appellant's relying on. And the problem is the evidence in the form of testimony and the language of these other documents is all you need to demonstrate the work order's existence. You don't need their physical presence in the record.
Let's talk about the missing work orders. My understanding is there's 390 townhome units and there's 71 buildings, correct?
Correct.
Okay, what evidence is there that the work orders or the job orders commissioned work for a particular townhome unit as opposed to a particular building?
Okay. As far as the unit by unit versus building by building, I mean, what we have right now is the master agreement language, which says it will retain a retain a subcontractor on a house to house and or building to building basis.
Right.
You have the Schedule A's, which say similar language, and you have Mr. Pierce's testimony confirming that these purchase orders existed and that these payments represented the completion of each contract for each unit. You don't have much more distinguishing between to tell us whether the work orders retained Hermie for a unit or for a building. And so we have to go by the unit date because that is a separate improvement to real property.
Why does that not matter? Why does that not hurt your case? If my view of the contract requires that the work order be incorporated because that was the actual engagement when the contract became binding, and I don't know if the work order is per unit or per townhome, doesn't that make your case very difficult? Because now I don't know what the scope of the contract is.
No, because each individual unit was issued its own certificate of occupancy representing that unit was complete. And that's from the testimony of Mr. Pierce explaining that each certificate of occupancy issued to each unit represents that unit's completion. So if different certificates of occupancy were issued for different units within a building, that unit is complete. And based on Mr. Pierce's testimony, that issuance of the certificate of occupancy indicates that the subcontractor's work on that unit is also complete, coupled with payment. And so the appellant has this thing that they're calling the half roof dilemma about whether you have a unit or a building. And there was actually no evidence presented in the record to go to the question that was asked earlier regarding whether a unit can be complete while the rest of the building cannot. As far as their hypothetical, they're actually conflating the statute of limitations with the statute of repose, because their concern is that if you have a roof that's leaking in one half of the building and not the other, the one unit owner whose roof is not leaking would run out of time to bring suit. And that's conflating these two different limitations versus repose issues, because limitations is what's based on notice of the defect. It's based on the accrual of the cause of action. Whereas repose simply extinguishes a right to an action regardless of whether the cause of action has accrued. So regardless of whether the unit owner is aware of this roof defect, it's just that's the statute of repose. The cause of action is extinguished in 10 years, regardless of whether they're on notice. So that hypothetical doesn't really work.
Let me ask you, what if the work order had language along the lines of, this is a work order being issued pursuant to the contract issued by the parties and referencing the Schedule A, and will not be considered a separate contract? What would that do to your argument?
Well, I think the problem is we don't have that evidence in the record to evaluate, Your Honor. But if that were the case,
and who has the burden?
Well, the burden to prove that it was a contract lies with us, and so far we've met that. If they come forward with counter evidence showing that this is the language that existed, well, that may change the game. But it's still, you're entering into a contract to say that it's not a contract. It's still written language that people are agreeing to. So
well, it could be part of a contract, right? I mean, you could have work orders be part of a larger contract.
You could,
Just
but then
like
the question,
you could have payments be progress payments on a larger contract.
of course,
My
Your Honor.
concern is from the record, how can we determine which one it is in this case?
Well, then the problem that then becomes what happens when you look at the master agreement? What happens when you look at the Schedule A's? Because if you look at the master agreement, because it doesn't relate to any particular project whatsoever, it could go on conceivably endlessly. Hermie may have other projects it's working on under that agreement. It may have more projects in the future under that agreement.
Well, let me ask you this, because I'm
Yeah.
trying to figure out the trial court's order here. The trial court found that the contract between the parties was the Schedule A's together with the terms set forth in the master agreement. Is that consistent or inconsistent with your position that the contracts were each work order and therefore for separate units or separate buildings?
way the contractor, or excuse me, the way the court wrote its order was not, with respect to that issue, maybe the clearest, but I think the court's ultimate holding reflects that he's considering each work order to be the operative contract, because he goes on to say the master agreement, the Schedule A, you can't really look to those because they never establish a definitive completion date. He talks about the Schedule A, where there's this effective date range for prices. The effective date range does not establish when the actual subdivision will be complete. It only establishes how long these prices for application of stucco will be in effect. And the problem that you run into, as the trial court mentioned in its order, is that you could have a subcontractor that enters into a Schedule A with Pulte, and then Schedule A later issues it a work order to do work on the first unit in the subdivision in 2005, but then may never issue any more work orders again without expressly terminating the Schedule A. And so you run into a situation where the subcontractor could be on the hook for years and years waiting for the subdivision to be complete with no clear end for work that it only performed on one unit. And that's just not reasonable, which the trial court came to the conclusion in, and I believe a footnote in its order.
Okay, but is the trial court's result inconsistent with that particular legal conclusion that I just mentioned?
Well, no, I mean, the master agreement is a contract and the schedule agreement is a contract. And I think they both set out terms which encompass this project.
Well, but the trial judge said the Schedule A's, together with the terms set forth in the master agreement, constitute the contracts between the parties for statute of repose purposes.
Right.
But
And
I wasn't just saying it's a contract. It was saying it's the contracts for statute of repose purposes.
Right. And I understand that. And I think, you know, the two problems there are, number one, his ruling then goes on to rely on the work orders. And I think the ultimate holding that he makes may contradict that statement a little bit. But if you look to those contracts say, as part of their contractual language, that these work orders will be issued as a separate document. And so even if he's finding that those are the contracts to look at, he's saying you still have to be cognizant of their terms and be aware that they contemplate additional work order contracts. And so
is it your position that there was at least 71, somewhere between 71 and 390 separate contracts?
I believe there were somewhere between 1 and 390 separate contracts. I guess you're asking if the work orders were issued on a building to building versus unit to unit basis. And I think that could be the case. If they were issued on a unit to unit basis, then it would be between 1 and 390 contracts. If they're issued on a building to building basis, then it would be 71 individual work orders. Yes.
Okay.
So the problem, another problem that you run into here is they're arguing, well, if it can't be the master agreement, if it can't be the Schedule A's, then you have to look at the last certificate of occupancy at the project, which was issued in September of 2008. And I think it's very important to recognize that doesn't work here either. And that's the big issue in this case, is if each unit can be treated as a separate improvement to real property. Because if you have a unit owner that, well, to back up, we know these certificates of occupancy were issued on a rolling basis between 2005 and 2008 as units were complete. And we know that certificate of occupancy indicated that a unit owner could purchase the unit and move in. And we actually know, based on the warranty deeds that are in the record, that that's exactly what happened. So you could have a unit owner purchase a unit in 2005 as soon as it's complete, and you can have another unit owner purchase a unit in September of 2008 when that last certificate of occupancy happens to be issued for that last unit that they randomly decided was the last one to be completed. Well, suddenly you have an unequal situation where you have one unit owner who has now a 13-year statute of repose and a unit owner who has a 10-year statute of repose, which obviously is an unequal situation that the legislature did not intend. And that is also yet another reason why you can't look at the effective date range in the Schedule A, because you run into the same problem. If you have a unit owner in the beginning, they have a 13-year statute of repose. And if you hold at the end of the Schedule A date, the effective date range is the date, then that last unit owner only gets the 10 years from, or 11 years from 2008.
Let me ask you about, you mentioned the intent of the legislature. Let's say that you had a 10 building contract. If there's, no dispute, is one contract, and it said these 10 buildings are part of the, the contract, and it's one project, one contract, and one building is built in January or finishes in January, and the second building is March. Every 2 months there's a building finished. Are you saying that the statute of repose would run separately from completion of each building, commence for each building, even though there's one contract?
I think it really depends on the situation. I mean, if you have clear contractual language of one contract that says we are contracting you to do 10 buildings, that's it. And there's no master agreement. You don't have Schedule A. You have one clear contract. That may present a different situation, but we haven't done that analysis because that isn't the situation here.
Right, but under my hypothetical and your argument, that would mean that one homeowner had a 10-year and 10-month statute of repose, and another one had a 10-year.
Well, it does present a problem. And when you look at the legislative intent, maybe we don't even go that far. Maybe we have to look at each project, at each unit as a separate improvement to real property in that sense, and say, when you're looking at completion of the contract, you have to look at the completion of the contractual duties for that improvement to real property. And maybe that's how we have to interpret the legislative intent. I haven't done that full analysis since that's not the situation here, but it does present a problem. And so, with talking about the legislative intent, the legislature set forth, as you've recognized in your opinion in the UCF case, Your Honor, that the legislative purpose is tied to the completion of improvements to real property. And so that's the key language. That means you look at each improvement to real property, you look at each unit separately. They also talk about how the purpose is to limit the time period for suits to be brought so that the people of the state may be served by basically minimizing the cost of insurance coverage of construction so that these costs are not passed on to the consumer. Under the appellant's argument, there is essentially no certainty as to the repose trigger, and that will cause insurers to raise premiums. And I know that's been addressed a lot more fully in one of the amicus briefs that was submitted. But this becomes especially true if you hold that the endless master agreement is the repose trigger. So each unit definitively has to be the individual improvement to real property measured by the completion of the contracts related, the contractual duties related to that unit. And so, Your Honors, thus the only date that could be used in this case were the dates of issuance of certificates of occupancy for each unit. And when Pulte issued its notice of claim and filed its lawsuit in March of 2017, more than 10 years had elapsed for the majority of those units. So based on these arguments and those set forth in our brief, we would ask that this court affirm the trial court's ruling in this case. Thank you.
Thank you. Any other questions?
I have one real quick question.
Of course.
Is there any evidence in the record that Hermes Simcor were licensed contractors?
Licensed contractors?
Yes, sir.
I'm not sure that issue has come up. I don't know that there's been any evidence one way or the other. I don't know that anyone's raised that issue at the trial court level. There's also no evidence that they were not separate and distinct companies, because I know that was mentioned in the appellant's initial argument. But thank you, Your Honor.
Thank you.
All right. Any other questions from the panel? Okay. Thank you. Rebuttal.
Yeah, thank you, Judge. I just want to go back and correct one thing. I just looked it up. The contract with Semicor was entered into November of 2017, not 2018, which, by the way, is
2007, not 2000.
I'm sorry, 2007. Thank you, Judge. Yeah,
Do you agree
2007,
that-
not
do you
2000.
agree with what counsel just said, that the evidence doesn't really establish whether Hermes and Semicor were the same company or different companies?
Well, they're different companies, but they were performing the same work in the same community. CO is just not the latest date. There's still work to be performed under the contract. You can't sue under the work order. The work order doesn't create a separate cause of action. You would be suing under the contract. And the lower court agreed that the contract is the agreement with the incorporated Schedule of A. So there can only be a breach of the master agreement. It has the relationship. It has the boilerplate terms, what they're supposed to do. You're supposed to do the stucco work when we give you the Schedule A. The Schedule A is within that 10 years, has all the essential terms are in the Schedule A. And by the way, appellee concedes there's offer, acceptance, consideration with this master contract. And that master contract incorporates the Schedule A's. The work orders, they're notices to commence work. Hey, here you go. You got to go out and do this work now. And the one thing I want to say is about the contract. They're saying, well, 13 years, that would be unfair. You had the ability to contract that away. Freedom of contract. You knew going into this contract what you were agreeing to. And so I would also say that the appellee had the ability to change the specific contract language on termination. They did not do that. And the contract language matters. Bush versus Lennar, another case right out of your court. Contract is not complete if the terms obligate the parties to act even after completion of the contract, which this contract did. I would also say in closing too, that limitation defenses are highly disfavored, and any doubt in the facts or legislative intent, the latest possible date should be utilized. I cannot reiterate enough Allen versus Conrad. And there's one repose date in that case that was established by this court for each project, not for a subpart of the project. The completion of the contract involving a subpart of a larger improvement to real property does not trigger the statute of repose period, so long as work on another contract involving the improvement was still going. Not only is there work on another contract that is within that repose period by the engineer, there is work by the appellee that still needs to be done in this community under their contract. This townhome association is one singular improvement to real property. It just consists of multiple parts, multiple units, multiple buildings, and it's operated by one HOA that has the responsibility for this real property. I would just say in closing that the purchase of your home for most of us is the largest investment for any person. And the trial court ruling, it severely complicates the remedies for that investment. And it creates uncertainty. And personally, I think it also defeats public policy, the legislative intent. It means something when they say the latest date. These are the trigger, the latest date controls. Thank you, judges, for your time.
Thank you. Any other questions from the panel? All right, thank you. And we'll be in recess till 10 o'clock for our next oral argument.
Thank you, Your Honors.
Thank you, Your Honors.